Hello everyone, I welcome you all again in Lawyer Stuffs. And today we have come up with a topic which is a landmark judgment, and that is Maneka Gandhi versus Union of India 1978. This was a very long judgment. So basically, what were the previous development before this case? The Keswananda Bharati case was in 1973, and after that an emergency was imposed in 1975, and we had our 42nd amendment, and after it we also had our 44th amendment. After emergency, the very first non-congressy government was formed. That was the government of Morarji Desai. He was elected as the Prime Minister of India. Firstly, let me introduce you with the case. So this case, Maneka Gandhi versus Union of India, is a case of a woman who is a journalist and was getting ready to attend other country for official work. So she applied for the passport under Indian Passport Act 1967, and her passport was issued on 1st June 1976. On 4th July 1977, Maneka Gandhi received a letter from the regional passport officer intimating to her that it had been decided by the Government of India to impound her passport under Section 10 subsection 3C of the Act in public interest. The petitioner was required to surrender her passport within 7 days from the receipt of that letter. Maneka Gandhi immediately addressed a letter to the original passport officer requesting a replica of press release about the explanation for creating the order as provided in section 10 subsection 5. After that, a reply was sent by the Government of India, Ministry of External Affairs, on 6 July 1977, stating that the government decided, in the interest of general public, not to furnish her a replica of statement of reasons for the making of orders. Then Maneka Gandhi filed a writ petition under Article 32 of the Constitution of India, challenging action of presidency in impounding her passport and declining to grant reasons for doing so. She also challenges Section 10 subsection 3C unconstitutional because it's a violation of fundamental right under Article 14, 19, Clause 1. Let's have a look on some of the main facts regarding the case. The petitioner was Maneka Gandhi and the respondent was Union of India. The citation of the case was 1978 AIR 597, 1978 CSR 2 621. The date of the judgment of case was 25th January 1978, and it consisted a bench of 7 judges. I'm sure you all want to know why the case was filed. So basically, Maneka Gandhi is an Indian politician, animal rights activist, and environmentalist who filed a writ petition under Article 32 of the Constitution of India, challenging action of government for impounding her passport and stating reason behind doing so. She challenged Section 10 subsection 3C unconstitutional because it's a violation of fundamental right under Article 14, Article 19, Clause 1. Here are some background facts of the case. The petitioner Maneka Gandhi's passport was issued on 1st June 1976 as per Passport Act of 1967. On 2nd July 1977, the Regional Passport Office ordered her to surrender her passport, and the petitioner was not even given any reason for this arbitrary and unilateral decision of the External Affairs Ministry citing public interest. The petitioner approached the Supreme Court by invoking its writ jurisdiction and contending that the state's act of impounding her passport was right-away assault on her right of non-public liberty as guaranteed by Article 21. It's pertinent to say that the Supreme Court in Satwant Singh Sahani versus Ramanathanam held that the right to travel abroad is well within the ambit of Article 21, although the extent to which the Passport Act diluted this particular right was unclear. The various issues raised in this case were: first, What is the scope of procedure established by law? Second, whether the right to travel abroad is in Article 21. Third, a legislative law that takes away the right to life is reasonable or not. Fourth, whether the Section 10 subsection 3c of the Passport Act violates the Article 14, 19 and 21 of the Constitution. The articles that were violated are: first, Article 14 of the Constitution of India; second, Article 19 of the Constitution of India; third, Article 21 of the Constitution of India. Section 10, subsection 3c clearly violates Article 14 of the Constitution of India because it confers the undefined power of the passport authority. It also violates Article 21 because it doesn't prescribe the word procedure within the meaning of the article. It also violates the Article 19 of the Constitution of India, Article 19 Clause 1A and Article 19 Clause 1G because it permits to impose restriction on the right which are guaranteed by these articles. Also, they cannot even impose these restrictions under Articles 19 Clause 2 and 19 Clause 6. And finally, the judgment of this case was passed by the bench of 7 judges. This landmark judgment came on 25th January 1978 and altered the landscape of the Constitution of India. This judgment expanded the scope of Article 21 exponentially, and this judgment truly and really made India a state as promised within the preamble. The major findings were: first, the court held that though the phrase utilized in Article 21 is procedure established by law rather than due process of law, however, the procedure must be free from arbitrariness and irrationality. Secondly, Constitution is found for the protection of citizens of India, and such interpretation of Article 21 are going to be counterproductive to such protection. Third, the court overruled the Gopalan by stating that there's a singular relationship between the supply of Article 14, 19 and 21, but during this case, the court held that the provisions don't seem to be mutually exclusive and hooked into one another. The fourth was that it was held by the court that the scope of private liberty has got to be understood within the broader and liberal sense. The fifth was that the correct to travel abroad as held in Satwant Singh is within the scope that guarantees mentioned under Article 21. Sixth, Section 10 subsection 3c of Passport Act 1967 is not violative of neither Article 21 nor Article 19 and also not in contradiction of Article 14 in respect of the said Act. The seventh was that the court held that the Section 10 subsection 3c and Section 10 subsection 5 is an administrative order. It is hospitable challenge on various grounds like malified, denial of natural justice, etc. And the final finding was that the court also suggested government should rarely use the prerogative of Section 10 subsection 5 of the 1967 Act. The significance of the case Maneka Gandhi versus Union of India was: first, the judgment expanded the scope of Article 21 exponentially by interlinking Article 14 and 19 to meet the requirement for any valid procedure. Secondly, the court, while delivering this landmark judgment, changed the landscape of Constitution by holding that though the phrase used in Article 21 is procedure established by law instead of due processes of law, however, the procedure must be free from arbitrariness and irrationality. And lastly, no person shall be restricted to travel abroad. So guys, this was all regarding the landmark judgment Maneka Gandhi versus Union of India 1978. I hope you all liked this video and don't forget to like, share and subscribe to Lawyer Stuffs. Thank you.